If you have been falsely accused of domestic violence, then this video is for you because I'm going to be going through 10 phrases that are red flags to judges when you are trying to explain yourself. By the end of this video, you're going to have a much better idea of what these red flags are so that you can avoid them. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything you need to know to represent yourself at a restraining order hearing and win. So if that is something you are interested in, you can get your free first class in the course via the link down below. Okay, so let's jump right in. The 10 phrases that you should avoid when you are testifying or trying to explain that you are innocent of these domestic violence lies, these allegations against you. Now, when I'm preparing a client to testify, whether it is for a jury trial or a restraining order hearing, I usually, as we're having this conversation, will make them a not to say list. Like, avoid these topics, avoid these keywords. And these are 10 that I noticed were coming up again and again as words that or phrases that I'm telling them not to say. All right, number 1. Disrespected me, especially if you say it like that. I don't know if I'm getting it exactly right. Look, everyone should respect one another, right? But there's something about saying disrespected me. She disrespected me by doing this and that makes it sound like you are about to hit the other person. And it's not really relevant if the other person disrespected you. If you have been accused of criminal domestic violence or the alleged victim has filed a restraining order against you, it doesn't matter if they disrespected you. What matters is, did you do what you are being accused of? Number 2, talking about kicking her out or it's my house if you lived together. Look, if you are the one paying the rent, it's your house, you've owned this house for many years, you've been paying the mortgage, I'm with you. It's your house. You should be able to kick someone out if you want to. But that's not how it works necessarily. Domestic violence laws in the state of California were made to protect domestic violence victims so that they don't end up on the street or homeless. Now, of course, that means that we have people who end up homeless even though they own a home, or literally couch surfing or sleeping in their car or spending all their savings on a hotel. That's the result of these restraining orders and these move out orders and these laws. But that is the state of the law. If it seems like you were going to do an illegal eviction because, yeah, even if the other person wasn't paying rent, you can't just throw them out or change all the locks right away, then that may lose you some serious points with the judge. Number 3, lost control. You don't want to talk about losing control, even if the next thing that you're going to say is, and I yelled at her, which is not a crime, although for a restraining order court, it could potentially be disturbing that person's peace. You want to give the impression that you are always in control. You are calm. You are not losing control. Number 4, if she was a man or any flavor of that. You want to avoid any testimony about that, any text messages that you have where you say if you were a man, I would throw hands at you. You want to avoid any of that if possible during the restraining order hearing. Number 5, wrestling. This is bad. You've been accused of domestic violence. Talking about wrestling with somebody who's probably smaller than you, it's not good. You're admitting to a physical altercation here, and it's overly general. So if there was some sort of self-defense situation where the other side attacked you and you were defending yourself, we'll describe it step by step. Do not reduce it to wrestling. Number 6, any argument that if you had done what she's saying that you did, that you would have hurt her worse than she's saying she was hurt. This one does not look good either. And it's not true. I mean, it doesn't matter if you are 6'5" and 300 pounds of pure solid muscle and she is 5 feet and 100 pounds soaking wet. It is possible to punch someone or slap someone or attack someone with varying degrees of force. If you are arguing this, you are already losing, and you should not really be arguing to the judge when you are giving your testimony as essentially a witness. Number 7, she has done it to me before too. By saying too, you are admitting that you did it. So that is not good. And talking about previous instances of domestic violence on the other party's part may or may not be relevant. The time that it would be relevant is if you were describing using self-defense or how you thought you had to use self-defense. You know, the other person has repeatedly attacked you. This time they just lunged at you and you grabbed them by the arm so that they would stop doing that. Well, it's relevant to explain that they had attacked you before, and so you were reasonable in believing that they would do so again, and you had to grab them to stop them. Number 8, very patient. That phrase is problematic because it sounds like the other person was testing your patience. And when people's patience is tested, sometimes they lose their patience. Number 9, frustrated or very frustrated. That is the same reason. People who commit domestic violence, many of them are feeling frustrated or very frustrated when they do so. Number 10, try to stay away from, and this is a general rule, it is on a case-by-case basis, but about the other side, cheating. You do not want this to be the main focus or provoking you, because these are situations where someone is likely to lose their temper after being very patient and feeling frustrated and engage in this wrestling with the other person that is domestic violence. And for these domestic violence cases, whether it is a criminal case and you do decide to testify, or whether it is a restraining order case, it is all about credibility of you and the other person. The judge has to look at you, or jury in criminal cases, and decide what kind of person is this. So if your face is turning red, you're looking angry, you're raising your voice and talking about how you became frustrated, your fist is clenched, right? That's not good. You seem like an angry person. Maybe you're just angry because you've been falsely accused, right? But it still doesn't look good for you. And if you want to win your case, you should avoid all of that. I hope you found this video helpful. Remember, if you do have a restraining order hearing, you can represent yourself and win. I mean, the hardest part about learning anything is that you don't know what you don't know. So in my restraining order course, I teach you exactly what you need to know and give it to you all on a silver platter so you can be ready for your hearing and represent yourself and win. If you did find this video helpful, please don't forget to like, subscribe, ring the bell, and follow me on TikTok, Instagram, and Facebook.